Cox, your drinking and use of drugs has brought you here for sentencing. It was your choice to drink and drive. It was your disregard of the law and the security of others using the highway which caused the death of the victim. If you had exercised just a little bit of judgment, you wouldn't be here today. From reading the pre-sentence report and the police report, I take it that your husband was either present at the game that you attended with your son, or he was close by and you could have had him drive you and the children home. You had a cell phone. You could have called somebody. You could have called a cab if one was available. You could have called a neighbor. You could have done any number of things. You could have asked a parent at the game to take you home because you were not in condition to drive at that time. Apparently this is not the first time that you've been intoxicated and violated the law, but on a previous episode you didn't learn from that experience. You have a history of drinking, and like most persons who drink, it is all about you. You drink because you wallow in self-pity, and thus you do not take responsibility for your actions. You look upon this death as a horrible accident in which the role that you played is minimal. You feel you are a victim of circumstance. Your explanations minimize your responsibility for the death. In my reading of the pre-sentence report, the police report, the mental evaluation, and your plea to the court, I have concluded that you have no real remorse for your actions, only excuses. You say you are sorry for your actions, but you continue to advance reasons why you are not fully responsible for the death. You know that you killed another human being and left him at the roadside to die. And you insist that though you thought that you hit a deer, a mailbox, or that a raccoon ran in your path and you had to swerve. At your plea hearing, you said, "I didn't see anything in the road." Which explanation is correct? There is evidence, however, that you immediately knew what you had done because you said, "I think I hit someone." "I think I hit someone" does not mean a deer or a mailbox. The severe damage to your car alone should have alerted you that something dire had occurred, and a reasonable and sober person would have stopped to determine what the facts were that had occurred. At your plea hearing, you told me that the weather was bad, again trying to justify your claim that you didn't see the victim on the bicycle. However, a witness testified under oath that the weather was clear. Certainly he testified that a storm was brewing. However, he testified also that at some distance he saw your automobile, that he heard the impact, and when he got to the scene, he was able to discern your car disappearing over the rise in the road. So it was clear enough and light enough to see others on the road. Your blood alcohol test was 0.284, and this was 3 hours after the event. You told me at the plea hearing when I asked you how much you had to drink, you said 1 glass. And in fact, you held up your fingers to indicate a small glass. What you don't seem to realize is that at the time you were tested, you were 2.5 times over the legal limit of 0.08. This means you were highly intoxicated and incapable of operating a motor vehicle, let alone making other decisions. Your irresponsible actions have destroyed 2 families, the Henry family and your own. I hope for your sake that from here on out you take responsibility for your actions and you make the proper amends. Kelly Cox, it is a sentence to this court that you will serve on count 1, a term of 8 years imprisonment for the crime of aggravated vehicular homicide. Your driver's license will be suspended for the rest of your life, and you will make restitution to the family for burial and funeral expenses. On count 5, attempted failure to stop after an accident in violation of section 4549.02A, the court sentences you to a term of imprisonment of 1 1/2 years to be served consecutive to the sentence imposed in count 1. Regarding count 1 and count 5 shall be served consecutive to count 1. The court finds the failure of the court to impose consecutive sentences would demean the seriousness of the offense and would not sufficiently punish the offender nor protect the public, and that the sentences are not disproportionate to the seriousness of the offender's conduct and the danger the offender poses to the public. Very well.